morning, folks, and a pleasant welcome. This is the Liberia National Television, and this morning we are coming to you live from the grounds of the Temple of Justice in Monrovia. This is where it is written on the word that justice be done to all men, despite your physical appearance, your wealth in society, but it is said that justice be done to all men. Today is the 26th of March 2025. I'm Aram Talu bringing you this live happening this morning from the grounds of the Temple of Justice in Monrovia. So folks, if you look straight ahead, you will see the Liberian flag up the Supreme Court of Liberia. This morning, you may be aware, on the 12th of December 2024, the embattled Speaker Kofa, after the Supreme Court of Liberia ruled in favor of the majority black, headed by now House Speaker Honorable Rachel Nangbe Kun on December 6th. The embattled House Speaker, now former Speaker, took a flight to the Supreme Court, asking the court to interpret her ruling. And on December 6th, during the court ruling that was read by Chief Justice Sadna Yo, according to Chief Justice Yo, the Supreme Court cannot do, I'm quoting verbatimly what the Chief Justice said in her ruling. And she said the Supreme Court cannot do what the legislative branch cannot do for herself. And in that ruling, many Liberians have said is followed deeping the current disputes that is currently going on at the 55th National Legislature, and to be particular at the House of Representatives. So it was based on that, the embattled Speaker, Councillor Kofa, took a flight on December 12th, 6 days after the Supreme Court ruling, asking the court to interpret her ruling. And today is set for the Supreme Court, the full bench of the Supreme Court, to interpret that ruling. And lawyers representing both the minority and the majority black have already started arriving. Upon our arrival here, the arrival of Councillor Vani Shemon. You know, Vani Shemon is the former senator of Grand Caymon County, and he's the lead lawyer representing the majority bloc, and also lawyer representing the minority bloc are also here making their way into the Supreme Court, where the bill of information will be heard by the full bench of the Supreme Court of Liberia. So as it stands, the grounds of the Supreme Court is getting packed. As you can see, vehicles are everywhere. I'm yet to see the former House Speaker Kofa, but what I can confirm is the lawyer representing the majority bloc Councillor Vanny Sherman, and former senator of Grand Caymore County, is already here and just made a way to the chambers of the Supreme Court of Liberia. And during the February 10 of court opening in Nimba County, one of the associate justice at the Supreme Court of Liberia, Justice Yamin Kwakwek-Bese, describes the workings of the majority bloc as ultra virus, which also sparked huge public debates, and as we speak, there's a huge debate still going on. So today, hearing of the Bill of Information will clearly explain to both the majority and the minority bloc at the House of Representatives to know exactly and to further explain in details regarding the ruling that was done on December 6, 2024. So this is where we are. We kindly ask that you sticking still as we bring you live happening. I'm here to see NN representative, even though this hearing is expected to commence 11 a.m. this morning, and with the time 17 minutes to 11, I'm here to see any lawmaker from both the majority and the minority bloc. But what I can say is lawyer representing both majority and minority, quote unquote, at many McLean are here and currently making their way in the chambers of the Supreme Court of Liberia, where the full bench will again interpret her ruling, even though during December 6th ruling that was read by Chief Justice Sanayo, she said the High Court cannot do what the House of Representatives cannot do for herself. That ruling, many says, it is ambiguous, gave more doubt to the workings of the House of Representatives. So as we stand, Liberians are still doubtful. Liberians are still finding it very difficult to know exactly who is wrong and who is right. Right after today's Bill of Information hearing, we will know exactly who is the legitimate speaker of the 55th there at the House of Representatives. But as it stands, the grounds of the Supreme Court, the Temple of Justice, there is a free movement. I can say there's a free movement. People are going about doing their regular business, and we are still outside here to see whether we will see members of the 55th who come to be part of this ruling. Of this hearing. But what I can say is lawyers that are representing both the minority and the majority bloc are here and currently in the chambers of the Supreme Court of Liberia, awaiting 11 a.m. with the time 12 minutes to 11 a.m. I'm still awaiting to see any of the lawmaker who will come to be part of this hearing. But as you can see right ahead, one of the justices are here. As you can see right ahead there, you are seeing JUD3, meaning one of the associate justice is already here awaiting the 11 a.m. hearing of the Bill of Information filed by former House Speaker Gineton Fonati Kofa. I'm yet to see the man who filed in that particular Bill of Information, Grand County District number 2 Representative Gineton Councillor Fonati Kofa. And I'm also yet to see any member of the majority bloc headed by Speaker Rachel Nangbe as well. And I'm also yet to see any representatives yet. I'm also yet to see any representative, but what I can say, if lawyers representing both sides are already here waiting this bill of information that was filed by Imbato House Speaker Gineton Fonati Kofa on December 12, 2024, just 6 days after the Supreme Court of Liberia ruled calling on the House of Representatives to settle or matter, and they cannot settle what the House cannot settle for herself. So I'm seeing here, I'm seeing Councillor Johnny Momo. I'm also seeing the former Solicitor General of the Republic of Liberia, Councillor Daku Moba, also making a way in the Supreme Court of Liberia. All our lawyers are also here. So at this time, folks, we will take a break and resume in subsequent time. We will take a break now and make our way to the Supreme Court of Liberia to listen to the Bill of Information filed by Imbato House Speaker Gineton Fonati Kofa, calling on the Supreme Court of Liberia to interpret her own ruling. In that ruling, the Chief Justice says a court cannot do for the House of Representatives what they cannot do for themselves. So it is based on that. Many Liberians and pundits have said the ruling is ambiguous. I followed deep in. So I'm seeing Musa Hassan Belete, and also I'm seeing Musa Hassan Belete, Marvin Cole, also Dixon Sibo are also here. So these are folks from the minority bloc, and I'm also seeing some of Boshua. I'm seeing Dixon Sibo. They are making their way from the Supreme Court of Liberia. So folks, like I've been saying, I'm seeing Honorable Yege Koluba dressed up in the traditional clothes, making a way to the Supreme Court of Liberia. So we're here.
Honorable Yege Koluba, you just interrupted the previous of the Temple of Tradition Person, another Joseph Walker. Joseph Walker is now tradition person. They have matches on it. We will not disrespect the Supreme Court. The Supreme Court is where all of us should come.
And we should respect these people and know that whatsoever decision they make, I will respect it. If the decision is not in our favor, I will respect what the Supreme Court.
Well, you said honor Speaker.
If the Supreme Court recognize him, I will say honor him. I got nothing different. I want all of us to do this.
Okay.
Yeah, if the Supreme Court recognize him, I will say honor him.
Will you call your colleagues to do same?
Well, I'm calling on all my colleagues to respect the Supreme Court. This is the only place we get. This is the only respected branch of government we have in this country. The executive is not respected. The legislature is not respected because we are all 419 people and criminals. So the Liberian people do not have respect.
Okay, thank you so much.
Okay, so
District number 10, Representative Yeke Kolwa, according to him, he will fool it abide by ruling from the Honorable Supreme Court of Liberia. Mind you, today is the build of information hearing by the full bench of the Supreme Court of Liberia. This bill of information comes 6 days after the Supreme Court of Liberia ruled calling on the House to settle her own matter. So I'm seeing Honorable Austin Taylor. Austin Taylor is from the members of the this is Representative Marco Thomas. I'm seeing Representative Honorable James Colette, Honorable Marco Thomas. Honorable Colette, good morning and welcome.
How are you doing?
Good morning, how are you doing?
Now you are proceeding to the Supreme Court after 6 days when the Supreme Court rules. And
after what, 6 days?
yes, the Supreme Court ruled on December 6. 6 days after Councillor Kofa filed a bill of information, which was on December 12. That's 6 days. And calling on the Supreme Court to interpret her own ruling. You are Antonia Law. How could you interpret that?
Not Antonia Law. Perspective.
Okay, perspective. Yeah. So how can one interpret her own ruling?
Well, I have that kind to interpret ruling. I do not have that jurisdiction or that power, that authority. The authority to interpret the opinion of all opinions for the Honorable Supreme Court or any other for the executive is quite lies in the hand of the Minister of Justice. So the Justice Minister did it and interpreted the opinion. So people who felt this in front charge with it, filed bill of information. But I would say this, I think if I were on their legal team, I think there was a little cash that they missed. I think one of the things they have done right after the opinion was rendered by the Supreme Court, they should have moved for a petition for re-argument. A petition re-argument who have avoided the Justice Minister interpreting the opinion for the executive, but the re-argument have an opinion. But in the absence of that, I just say to you, coming to bill of information, what next that is in there? The opinion is clear.
What more do you expect? What more do you expect
if the Supreme Court ruling go against you? Will you respect whatsoever the interpretation says?
Absolutely, there's no way the Supreme Court ruling can go against us. Then she will be contradicting herself. The opinion said to you, anything not consistent with Article 33 and 49 was ultra-virus. Okay. And for the 33 say you must have simple majority we had. So for 49 say you must have a presiding officer, which is the deputy speaker we had. So it means that we acted within the confines of the law.
One of the colleagues just said whatever decision the Supreme Court,
one of the suspended colleagues, modified suspended colleagues.
Okay, the suspended colleagues will say that any decision the Supreme Court comes up with today will be respected.
That tells you that he has accepted the fact that the opinion is against them. Okay. I said the opinion is clear. You must be able to meet Article 33 and 49. 33 says well, simple majority. Did we have simple majority? Yes. 49 says you must have a presiding officer. Did we have presiding officer? Yes. And who was the presiding officer? The deputy speaker. If you read Article 49, it says the House of Representatives shall elect every 6 years a speaker who shall be the presiding officer, a deputy speaker, and other officials for the proper function of the House. So it's clearly the person who did not meet the requirement. He didn't meet the requirement.
Okay, so he's the Honorable Kule of Bon County, District number 2. So folks, we are still here making sure we bring you the happening. Several lawmakers. We just witnessed the arrival of Bon County District number 2 Representative James Kule. Also, we saw Michael Thomas and other lawmakers also have made their way in the chambers of the Supreme Court of Liberia. So folks, in a moment for now, I will take me to move directly to the Supreme Court of Liberia. Majority members listening to hearing listen to the better information filed by former House Speaker Gineton Fonate Kofa. But District number 10 Representative Yega Koluwa made it very clear on LNTV and other media platform that any ruling from the Honorable Supreme Court of Liberia, he as an individual will abide by ruling from the Supreme Court of Liberia. So we are still here. We are still here witnessing, looking at a rival of representatives who are currently here making their way into the chambers of the Supreme Court of Liberia, awaiting a hearing. And this build information. Okay, so any moment from now, it is 11 already. Any moment from now, the build hearing at the Supreme Court of Liberia will commence, and the build hearing is be done by the full.
Representation. The informant represented councillors M. Wiggins Rabbit, Anton Johnson, Jonathan Masaku, and Elisha T. Council the ex in the of your honor. I respect for this subject.
The respondents Manigisho and Albert Sims, Prime and submit respectfully. Before the presentation, I may need to say that the first petition the name of party, the amended petition will not be party. So we got to come to in obedience to the to appear to hear what the court will say, whether it's to say or not.
Repeat that question.
The first information that we found in the second respondent. Now, the amended information, we were never made a party, but we found information. So, in response to say we started to come, so I have to be the responsible to the court. The what the court will still come to.
Okay, are you supposed to be a child who will have you make submission on the record, okay, and the court will respond appropriately. Thank you, SG. Any other representation? You already spoke, Councillor Singh? Oh, okay. All right. Representation. I noted. So, SG, can put it on the record. Mr. Deputy Marshal, do we have seats? Just 1 minute, SG. Do we have seats for those who are outside? Okay, let them come in at this time.
So folks, welcome.
We
are currently in the Supreme Court of Liberia. Today is the hearing of the bill of information filed by former House Speaker for the profile against the majority bloc. And we're here in the court with representatives from both the minority and the
proceed SG.
currently the full bench of the Supreme Court of Liberia here.
Initial proceedings in this case showed the Ministry of Justice was made party. The Justice Ministry indicated that this position consistent with Chapter 5. This is a position consistent with Chapter 5, Subsection 5.6. 5, Subsection 5.6 of the Civil Procedure Law. In this case, on the second ground, Justice of the second party, and we are here formally filing for brief. But the amendment, their information in the proceeding excluded the Justice Ministry as a party. Justice Ministry, in obedience to this report, started to come and maintain and always available.
Mr. Clerk, take this. And this case was called for hearing. Upon notation and representations, is the Solicitor General of the Republic of Liberia. Drew the court attention to the fact that the appearance on behalf of the Ministry of Justice was merely in obedience to the notice of assignment served on the Ministry of Justice. command. Also, that the original bill of information filed by the present petitioner included the Ministry of Justice or the Government of Liberia to the Ministry of Justice as a party. But in its amended bill of information, the petitioner did not include the Ministry of Justice as a party, did not name the Ministry of Justice as a party. What this would say that despite the naming or non-naming of the Ministry of Justice in the original bill of information and the amended bill of information, it is the law that the Ministry of Justice is called upon only in the instance where the Republic of Liberia and its parastatals are sued, and then the Ministry of Justice comes on the side of the law. Well, this case not being within the peripheral of this law or as contemplated by this law, the Ministry of Justice is excused from the bill of information proceeding, and it is hereby so ordered. Thank you. Employment, proceed.
May it please the court. This bill of information is brought specifically by the informants who asked this honorable Supreme Court to enforce this December 6, 2024 ruling in the case in re-petition to determine the constitutionality of certain members of the House of Representatives. The ruling clearly states that any act or acts of members of the House of Representatives that do not conform to Articles 33 and 49 of the 1986 Constitution of the Republic of Liberia are considered ultra-virus. In the context of the legal definition of ultra-virus, the action is unconstitutional, but those actions are unconstitutional. And that any action taken as a result of these illegal actions, they are void ab initio. The bill of information is intended for us to enforce our ruling of December 6. Yes, sir. The time of office of the information. One of the rule of this code is time of office of the information. The office of the bill of information is intended mainly to bring to the attention of the court that this particular ruling or decision taken in a ruling based on a case that they have passed upon when it is interfered by a party in the case or any other person, when there are actions taken by a party in the case that undermine the enforcement of that ruling and the enforced administration of justice.
Yes,
Your Honor, the Supreme Court has the authority, inherent authority, to enforce its ruling when it is observed that its ruling are being impeded by a party or a person who was part of the proceedings. And so the Office of the Data of Information, yes.
the judgment, they come back to want to get information for the right.
So Your Honor, will bring you to the judgment in December 6th opinion that you rendered, and in the case, taking case of his part, you rule that whenever the opinion of the court or anyone who engage in an act or act to undermine and impede the integrity or the administration of justice of the court, the party affected or the party who is to the attention of the court for its enforcement, informing the court of the flagrant violation of the court's decision. Yes.
Courts do not enforce judgments. The law places responsibility on an institution other than the court. The court's duty is to see what the law is. The Bill of Information has a specific rule as defined in the rule of court. So our concern now is you have come and you want to place the onus for enforcing our judgment or the judgment of the court on the court. So it is a little concern. Where is your reliance? What do you rely upon to say that this court can enforce the judgment that it has entered?
Your Honor, there are series of opinions divide, even though the enforcement of law is constitutionally the executive. There are series of opinions where the Supreme Court opinion have been violated, have been disrespected, and that parties are part who come to this whole
The Chancellor will want you to do for us now and to give us the understanding when they try to take. Is to state some of those cases that and then the matter informing me the court when they get to say that when we have the competence to enforce our judgment.
Thank you. In one of the cases we cited, the majority UCL and all versus minority UCL, the case decided in 1999, that is 39 LFR of 692. This would establish that the Bill of Information is the proper, where it is proper where the Supreme Court's ruling is being improperly executed, obstructed, and ignored. And that the next thing the Supreme Court has established is that anyone who violates or obstructs the opinion of the Supreme Court.
Let's see what I this on law that you are mentioning or something.
Yes, sir.
That law is saying that the proper office of the Bill of Information is what is supposed to require to somebody who has improperly or executed the post judgment, the execution of that judgment.
That's correct.
Are you equating that to mean that the court can on its own enforce its judgment? Is that what you are trying to say? So want to be careful with words. You are using the word.
You are not really enforcing your word.
Okay, so therefore,
so why are they asking you in substance to
we are all in agreement.
Counselor, we are serious here, please.
So what we are asking you specifically is to reaffirm your decision of December 6, 2024, indicating in repetition for this court to determine the constitutionality of certain actions of some members of the House of Representatives.
So, Councillor,
Yes, sir.
for us to know the level of our authority here, I would think that first we have to put to us the source of our authority when it comes to bill of information. What are the areas we can inquire into? You know, first let's establish that. What can we do when the party file the bill of information? What do we look for? First we have to establish that, and then the statutory or rules reliance. You give it to us so that we set that as a basis. You know, the yardstick for us to measure any argument that is going to be made before us. What are you relying on to file the bill of information?
Well, the rule of the Supreme Court, which on the bill of information.
Which rule? Cite the rule. Cite the rules. Let's know the rule that you are relying on.
The rules of the Supreme Court are specifically declared the line following any civil procedure.
What is the rule? What does the rule doesn't have to cite the rule? There was something there that
we didn't bring the rules of the Supreme Court with us yet. But we have that also in the civil procedure.
That's the strength. That's the strength of the case.
What the bill of information says in the rule of the Supreme Court.
The bill of information says that based on the rule of the Supreme Court is that first you must establish
information guide A, B, C, D, E.
Yes, sir.
Which one of them? A, B, C, D, E. Which one?
The honor it includes almost all of them. It includes almost all of them.
Name A. State A.
Yes, sir.
State A of the rule of the Supreme Court.
That's what it is.
And you cannot tell us the bill of information.
First of all, the honor, it has to do with the 2009.
No, we know what you have to do with
it. Yeah, the 2009.
What is part of the bill of information that it is supposed to do?
The revised rule of the Supreme Court revised part 1 says the Supreme Court shall meet in 2
I will get meet in 2 terms.
No, that's not. The bill of information part 12A.
Yeah.
They said the bill of information will lie to prevent a judge or any judicial officer who attempts to execute the mandate of the Supreme Court. That's how I say it. And the bill of information will lie to prevent anyone.
No.
Of the Supreme Court in an improper manner from doing so.
Okay.
The bill of information will also lie to prevent anyone whosoever from interfering with the judgment or mandate of the Supreme Court. The bill of information shall be venue before the court.
No. But you said all of them are applicable. You said no.
So, in the context of
the first two that we have read.
Yes, sir.
Okay, that the bill of information will lie to prevent a judge or any judicial officer who attempts to execute the mandate of the Supreme Court in an improper manner from doing so. Is that applicable?
No, that's not good.
Okay, so which one is
whoever. It's applicable whoever interferes. Yes.
On anyone whosoever from interfering with the judgment and or mandate of the Supreme Court.
That's correct.
Okay, so whosoever here.
Whosoever. So in this case, the whosoever was on the respondents in these proceedings. On December the 6th, 2024, when this court rendered its judgment, indicates the in-read petition.
We did not say what the law was in our opinion. We did not say it.
The ruling, your opinion, Your Honor, you said the issue of comparing, the effect of the opinion is that the fact that there is no law to actually compare, and that's what you said. Other members to extend sections to form the memo of a quorum for decision of sections. The law provides that the speaker, the legitimate speaker, with the members he has to continue to convene from time to time in order to encourage the other members of the majority back to come to power, to come to section. There is nowhere that the Supreme Court is in a there is a constitutional crisis that is stated.
The ruling on this one came from a petition to declare the constitutionality of the act. And that ruling said, look, you minority, if we proceed without a quorum,
That's right.
What specific mandate or instruction that you give that somebody found?
Thank you. That specific mandate is enshrined with Articles 33 and 49.
But this is that coming here. Our is the one of our debate that
they are very open.
In this ruling, we declare this right, you don't have the right, you don't have the wrong.
Yeah.
So what order do we get below that was there?
The order you gave below is you said in effect, in substance, you are saying none of these groups, the speaker black, the majority black, can conduct business in violation of Article 33 and Article 49.
So if that is the interpretation,
yes, sir.
if each party go and conduct business in a way we say should that be, is that also clear information?
Of course, Your Honor. Because yes, Your Honor.
I tell you that if you need to do a record, there's something wrong. You if you need to do a record, there's something wrong. So you see you need to do a record, you come back and all you go to
that anomaly does not go with the fact that Your Honor.
No.
Your Honor.
I think for the fighting over the use of the road, then you're right before you put it. But no, anybody who is going the opposite direction is being using the road. So you see your point going the opposite direction. You come back to the point where you travel go.
Your duty as a party in that case, based on the standard that you have set as the Honorable Supreme Court, the bill of information, is to come back to the Supreme Court by the standard that you set based on your ruling. This party is proceeding in a way that infringes on your rights and it undermines and impedes the integrity of the court. How did they impede the integrity of the court or undermine the ruling?
Why would they want a declaration?
Yes, Your Honor.
You want to read the full opinion. You want to put it for me? This court's interpretation of Article 33 of the Constitution is whether a
presiding officer defined in Article 11 of the Constitution is the Speaker, and in his or acting is the Deputy Speaker. Are you there? Okay. Very well, the Speaker is presiding over a minority. The Constitution is void of the mechanism or how the minority is to compare the attendance of active members, and the legislature has promulgated no deliberate statute or standing rules setting forth the process for comparing active members to attend session as envisioned under Article 3 of the Constitution. And one of these circumstances, the Supreme Court cannot do for the legislature what it will be expected to do, and to do so will be a violation of the constitutional mandate on the separation of powers. Wherefore, when you view the full way, any sitting or action by members of the legislature not in conformity with the intent of Article 49 of the Constitution is controversial. Hence, members of the House of Representatives are to conduct themselves accordingly. The clerk of this way is therefore to inform the parties and then is hereby to order. Remember where is the order that we give below our foundation?
You just state the order. The order is when you go back as members of the House of Representatives and you don't conform yourself to Article 33 and Article 49, your actions are unconstitutional.
Your actions are unconstitutional, right?
Yes.
So you come back to interpret.
We come back for you, Your Honor, because of the opinion that you gave. It has been disrespected. In effect, Your Honor. In effect, when you said
with a plan. The representative of this board is hereby ordered to inform the parties. That's what I'm saying.
Your Honor, allow me to proceed this way. The basis, I don't know, has still been corrected. Upon which the question is being filed, is being posed, they suppose it to mean that it has nothing to do with the constitutional crisis happening. But if this code is the constitutional code, and that the nation in the world is looking up to interpret and say what the law is by reinforcing or re-interpret the lesson enforcing its opinion of December 6, 2024. This code has jurisdiction. And that jurisdiction is a constitutional provision that you have declared and pronounced have been violated by the respondents. Yes, sir.
You know, when we come and start bringing our infusing all of these sentiments into a legal question and the law, you know, to be specific, it doesn't move this point at all. We read the Office of a Bill of Information and said the applicable provision of the rules of the Supreme Court is that to prevent anyone whosoever from interfering with the judgment and mandate of the Supreme Court. You more or less said that this court made a declaration that if you're on this side, this is how we see you. If you're on this side, this is how we see you. That's why I asked, why were you? Because we have a role to play there to go and ensure the promulgation of a law. Without doing that, you come now and say someone is interfering. How? Then I'm at a loss here, because where is the interference? Keep it from both sides. Where is the interference? In the first declaration. Where is that interference?
In the English informer.
Don't you think you just haven't done anything?
No.
Said that it lies with you, the House of Representatives. But right. This is what the law says. The Bill of Information, is this the Office of the Bill of Information?
This is the Bill
of the whole world looking at us. To say what Arthur Johnson wants us to say, the whole world looking at us to say what the layman wants to hear us say. Did we not state the law clearly and give you all a declaration because it will be what? Interference in another branch of government. Then you come here and say this court has jurisdiction. We know the jurisdiction of this court, and we apply our jurisdiction to say what the law is. Now you come up with information. It's specific. This is one rule of the Supreme Court that is specific as to the office of the Bill of Information. You say the applicable section is B, interference. So what is the interference? Not what the whole world wants to say. Answer that question. Then we're going somewhere.
So the interference of your ruling, Your Honor, is when the respondents went by based on the interpretation of this word, that you must be constitutionally sitting as a competent authority before you can perform legislative functions in Article 33 or 49 of the Constitution. They went further.
That's what according to your argument.
Your Honor, you didn't ask a question.
This is our court. That's what according to your argument there, that the other side, the other party, are doing X, Y, Z. Okay? They are sitting, they are doing this, they are doing that. It comes there again. Where is the law with us subjecting this court to interfering in the other branch of government? What gives the authorizes the court to tell them do not sit, do not do nothing, do not do anything? Where is that authority in the absence of how we can get that group to come on the other side? Where is that authority?
First of all, the authority is in the Constitution. The Supreme Court is the final arbiter on constitutional issues. The interpretation, the clear interpretation of issues of constitutional matters brought before the bench of the Supreme Court will follow D and D.
What was the issue brought?
The issue brought was the respondents accorded unto them an authority that was not described to them by the Constitution.
And what did we say?
You said that if you say as a body and you do not conform to the Constitution, you are ultra virus.
And on the other side, what did we say?
We also said that they are legitimate. The whole we never said that. Unless you said that the council
cannot say that. Read from the opinion what the court said.
No. In effect, if the Supreme Court, yes,
if we can't concede, we can't move forward. We never use the word legitimate for.
No, I didn't say it's not that we expressly stated
no, I didn't say it.
But when you said that the speaker, the presiding officer of the House
Councilor, please read it from the opinion. Read it from the opinion. Yes.
Read the opinion, let us state that the informant is the legitimate speaker. They didn't say that. But this would also recognize this, that the legitimate speaker of the House of Representatives is the informant, co-informant, Councilor for Nancy Kopa. Unless the Supreme Court says that the opinion that they gave on December 6th did not recognize the informant or Kopa as the speaker of the House of Representatives.
I think it's less preference. And
Councilor Johnson.
Yes, sir.
Take you back to the definition of the office of the Bill of Information. According to your reading, the Bill of Information has legal rule to fulfill. That's it. One is to prevent the judge,
Yes.
or the judicial officer from attempting to execute the mandate of the Supreme Court. For interfering with the execution of the mandate of the Supreme Court.
Yeah.
That's the first one. The second one, which you say is the basis of your bill of information, is that the bill of information will also lie to prevent anyone whatsoever from interfering with the judgment and or mandate of the Supreme Court. And I think this is where the question is coming from. We are having very, very responsive. Okay, the first thing that we want to know is what was the mandate of this Supreme Court that was transmitted to the parties? What was that mandate? What did the Supreme Court see in that mandate? First, when we get that, when we get what the Supreme Court said in that mandate, then the second thing that we want from you is we will develop to us how that mandate was, I want to be very specific, yeah. Yeah, how was it interfered with? Who interfered with you? So that's that gave us the mandate. Well, yes, the council came accurate with the Supreme Court, that is specific. What was the mandate? What did the Supreme Court say that was supposed to be executed, that was supposed to be obeyed, that was supposed to be followed, that was supposed to be adopted? What did the Supreme Court say? When you gave us that first, then you go to the second point now. How was that interfered with? That's the second one. And by whom? And how? So when you get it to us that way, then we'll be able now to make a sense. Well, when you're trying to
thank you, Justice Kala.
So first, what is the mandate?
The mandate of the Supreme Court.
There's sometimes when you are pleading, you don't plead in a way to present all the information and get yourself choked. In my own opinion, you are saying you are finding a bill of information based upon the interference with the post mandate. That mandate is certain that being part of your pleadings. That mandate should have been before us, so that when we look at it, we know exactly what we are saying. But currently, you don't have to mandate them with you. This is the mandate of what the Supreme Court said. The court further ruled that any legislative actions. No, that's the mandate of the court is tailored in the second challenge. And when you see the court further rule, they tell you that you have really the mandate to do that. First, these are the things you will be capturing, we capture in your rules and your mandate. That the members of the House of Representatives will go and conduct themselves in line with Article 33 and 49 of the Constitution. And that any sitting that is carried out, I don't think the best thing we can do is maybe you let someone opening, get yourself prepared, and the law market or something, let's hear from them, because you still not giving us the information that we desire. The information we desire is you say somebody interfere with the mandate. Tell us what our mandate is. You don't know the mandate. You are trying to fence around all kinds of things, So you don't know the mandate. I know the mandate. I don't have the mandate here, but I read the mandate. I remember the answer. How could you convince us now that we coming there on our If it was part of your feeling, it would be needed. It's not there. There's nowhere to be found. Nowhere in the Supreme Court. And you say it was down there. Interfere with. What is it? The mandate was, Your Honor, that members of the House of Representatives are to conduct themselves accordingly. According to what? According to Article 43, 33, and 49 of the Constitution. According to yourself, in the line of opinion that the Supreme Court interpreted what Article 33, how Article 33 and Article 49 can be applied. So if you get the mandate, if you had the mandate with you, then that mandate would have come up clearly and tell us, one, the Supreme Court said this, two, the Supreme Court said this, three, the Supreme Court said this. When we come up with those points now, then you come to the simple argument, how was that interfered? How was that outdated? Then what went contrary to, that's the way the argument should come. But what you're telling us now is you just making a lot of assumption trying to put things together that are there. That's our problem. The mandate should have been with you so that when you're talking about the mandate, you're looking at the mandate and you convince us about it. That's how you go acting.
So Councilor, you want to yield on the opening to close? So let's hear from the respondent.
Okay, we close on the opening.
Thank you. Respondent, you may proceed.
You said, having carefully examined the contentions of the parties, listen to the arguments on both sides, and consider the laws relevant there to the I judge that the Supreme Court, pursuant to Article 66 of the Constitution, shall be the final arbiter of constitutional issues and shall exercise final appellate jurisdiction in all cases, whether emanating from the Court of Record, administrative agencies, autonomous agencies, or any authority, both as to law and to fact. Hence, the Supreme Court has the jurisdiction to decide constitutional issues arising out of internal dissensions among the members of the legislature, as in the present case. That is the law involved that the Constitution must be interpreted in light of the entire document, whether there is a special pronouncement, because every provision is of equal importance. And even where there is a apparent discrepancy between different provisions, the court should harmonize them if possible. That this court's interpretation of Article 33 of the Constitution 1986 is that whether a simple majority is sitting or a lower number, in both cases the presiding officer, defining Article 49 of the Constitution, is the Speaker, and in his or her absence, the Deputy Speaker. That in the event where the Speaker is presiding over the minority, the Constitution is devoid of the mechanism for how the minority is to compel the attendance of absent members. And the legislature has promulgated no entitled statute or standing rules setting forth the process on compelling absentee members to attend sessions as a vision under Article 33 of the Constitution. And that under these circumstances, the Supreme Court cannot do for the legislature what is within its purview to do, as to do so will be a violation of the constitutional mandate of the separation of powers. Wherefore, and in view of the foregoing, any sittings or actions by members of the legislature not in conformity with the intent of Article 33 and from now the Constitution are authorized. This is what you can talk. Now, informers have not one moment said that there was a convening of the House of Representatives with all this majority. Nowhere in that constitution. That's Article 33 of the Constitution. And maybe for me, I want to say for you, because the court is presumed to know the law. For me, here's what it says: a simple majority of each house shall constitute a quorum for the transaction of business. Nowhere in the Constitution have they said, our respondents sat, they were there and said, nowhere. They have not proffered any little information is alleging facts. Facts to cause your own to say, you have violated our judgment, you have violated our mandate. mandate, or you have departed from our mandate or from our judgment. That's all.
Please clarify this one. You said nowhere has the informant formed this report by any of evidence that they had a sitting in which the asked other people to join the other people refused. Is that what I get?
No. I said nowhere did they say that when the respondent sat presided over by the deputy speaker, that they didn't have the simple majority requirement under the Constitution.
Well, he said the majority said with the deputy speaker.
Preside.
Was the speaker here instead?
Yes, Your Honor.
I'm talking about the informant, jail and people.
Yes, Your Honor.
And certain members of the House of Representatives.
Yes, Your Honor.
They were part of that sitting?
No. He chose not to go.
Is he the one to call into a meeting?
No, not necessarily. Not necessarily, Your Honor. Please, Your Honor, not necessarily. From my personal experience, the Constitution says who is the presiding officer of the Liberian State? The Vice President. The Vice President is the presiding officer of the Liberian State. But when the 99% of the time, who presides? The President pro tempore. Because when the Vice President is not present, the President pro tempore presides. So when the majority are seated inside, you, the Speaker, will go there and preside. If you are not there, and the Deputy Speaker is there, the Deputy Speaker has an obligation to go preside in the absence of the Speaker. Just like the President pro tempore normally presides in the absence of the President of the Senate. That's the Chairman. That's the Chairman. The scenario goes this way. There is irregular sitting chambers of the House of Representatives. The Speaker is in that regular sitting chambers of the House of Representatives. He has called for a session in that regular sitting chambers of the House of Representatives. He's there with a number less than a quorum. And the rest of the members are admonished of the fact that the Speaker. There is nothing called a regular sitting chamber. There is nothing like that. When I was there, COVID time, there is nothing called a regular sitting chamber. And if I may explain the other now, or I call it in our freedom. If there is a regular sitting chamber of the House, it's the word our called chamber, which is under revelation. That is the regular sitting chamber for the House of Representatives, if there is a regular sitting chamber. But there is no law.
The last one you go to the
Vice President is the presiding officer of the Senate. So if the Vice President is present, can any other person decide the Senate is present and decide? Can any other person go and empty that room? When he's present at the meeting, nobody has there. So when the Vice President called the meeting of the Senate, can another group of people go and call another meeting in another area to say that when you come and sit here, we are going to have a separate meeting? Is that your argument? No, Your Honor. Okay, my argument, let's bring that to the situation we are in now. Here is the Speaker sitting in the where the House normally meets. It may not be a particular place where they normally meet. The Speaker is there. He called the members of the House to come and let's meet in this place that normally meets. Come, let's meet and discuss this matter. Come, let's meet and be a session to have our session. Then some group of members refuse to go and sit in that area, and then go and invite, open another area and say, well, we are going to meet in this place here. Then, of course, we inviting you to leave from there and come to us. You come to us and let's sit here. I'm the presider, I'm the speaker. I was elected by you to preside over the matter. I called the meeting, and I called the section, but they said, look, I'm having a mountain section. The deputy speaker will be here, he will be presiding here, all of them come to us here. And so I'm asking you a question. Is that what is contemplated by the Constitution?
No, Your Honor, but let me explain. Let me explain. It is the majority that elected the speaker. When we came first, we came out a petition for a real position. And we accepted the positional justice. There is a complaint against the speaker's access members. Even before people was constitutionally. There is a complaint signed access members of the House of Representatives against the speaker. What you see going on there is the House of Representatives is trying to decide how to address or manage this complaint. And I believe on that basis, human justice having recognized the constitutional authority of the House to remove the speaker is an non-issue. And the party for that. It should also be recalled that place you call the regular chamber is a chamber with those who oppose by Romanico and others. And saying you, the majority, do not go like that before. Which all the majority go to the chambers?
Councillor Sherman. Those facts are not and will never be before the court. Those facts are not and will never before this court. So I will stop you right there. Congregate it out. Now, the present respondent, the present respondent, properly designated from the Honorable Richard Cole, Speaker of the House of Representatives and other members of the House of Representatives. In their brief, that's how they designated themselves. In the other people's brief, it was in the informant petition, and we asked the Speaker Kofa as the Speaker. Now, albeit this is a bill of information, this court will never forget that. But as you so meticulously read and provisions or sections of our ruling of December 16, 2024, let me refer you to page 21 of that ruling, starting from the second paragraph. The respondents for their part, that is Honorable Kuhn and others, for their part have counter-argued that they have already expressed a vote of no confidence in the leadership of the Speaker, that their quorum in the joint chambers of the legislature is legitimate for the transaction of businesses in next the constitutional requirement of a simple majority as prescribed in the Constitution and the rules, that their quorum is being chaired by a presiding officer in person of the Deputy Speaker, who is legally clothed with the same authority as the Speaker to preside over their deliberations in the absence of the Speaker, that they have cited the petitioners and other minority members of the House to attend session in the joint chambers, but they refused, and that they are constitutionally vested with the authority to conduct the business of the House of Representatives. And we said that, like the petitioners in this case here now, the respondent have also drawn our attention to the constitutional phrase, quote, a simple majority of each house shall constitute a quorum for the transaction of business. We went further to say there that, look, when they said about the issue of a vote of no confidence raised in their returns, this court has opined in the case Parkwood versus Jalad et al. Supreme Court opinion October 3rd, 2014, that, and I quote, the Constitution provides the framework within which the legislature operates, and any act, including a vote of no confidence that breaches constitutional provisions or due process shall be subject to the judicial review. So we said that both parties had relied upon Article 33. And coming to page 33, in interpreting Article 33 of the Constitution, this court says unequivocally that whether a simple majority is sitting on lower number, in both cases, a presiding officer defined in Article 49 of the Constitution is the Speaker, and in his or her absence, the Deputy Speaker. This is the court saying what the law is. Now, that story you are explaining and whatnot, we found certain aspect of it in the returns, in the original case that is now under review, that your clients have said, no, you did a thing of no confidence. Or we said that, look, this is the law, because they said that because we have a greater number, and we have this presiding officer, the deputy speaker presiding, and they didn't say where the speaker was or anything, but and we called the minority to come over to us. So we said, look, both of you have depended or relied upon Article 33, and this is how we interpreted Article 33. In interpreting Article 33, this court says unequivocally that whether a simple majority is sitting or lower number, in both cases, a presiding officer defined in Article 49 of the Constitution is the Speaker, and in his or her absence, the Deputy Speaker. This is the law. So if we want to infuse anything in it, we say, no, both parties, this is what the law says. Now go and govern yourself accordingly within the context. Then you come and say that somebody went no special place, rented no special place. But we said this is the law, and go and govern yourself accordingly. If there is a speaker that is provided for under the Constitution, he or she is and remains the presiding officer for the transaction of business. So in essence, where these people coming from, you say they voted and this and that, how did that take place?
Your Honor, the House of Representatives, and when I say the House of Representatives, the majority of them, before they themselves conceded that what we call the majority bloc was initially 43 members of the House. It's in the meetings.
Yeah, we have attached a listing there, and we say we're not going to even look at that listing because this court cannot take in evidence to call those signatories and names for them to appear here and to answer to their names. We're not even going to look at it, and we did not look at it. But we say this is the law, and go and govern yourself accordingly. So why was the presiding officer and present? Because I don't see how it comes to the Constitution here that you will be sitting somewhere and call the minority, or the minority under the Constitution is being headed at that time by the presiding officer designated or named by the Constitution as the Speaker.
I don't think your interpretation also create a paralysis, a dysfunction in the hospital terms.
No,
that was not your intention. That wasn't your intention at all.
I agree with you.
You said, in your opinion, you the minority, the Constitution provides that you can compare the attendance of the minority, but there is no mechanism for it. And we, the poor, cannot provide an mechanism for you. How else would the cost operate without the minority?
Notwithstanding, as I read the full text there on pages 31 and 33, we said that, look, as you practice it, we don't want to paralyze the House of Representatives because the law is clear. If you're not sitting, if you're not doing anything, the other component, the Senate, can do nothing also until you're sitting legally, both of you. That's the law. Okay? And we said here, look, Article 33 was the focus, vis-a-vis 49, of both parties' issue, was the issue by both parties. So we said, look, yes, we see you with your numbers, but this is the law as regards Article 33. You in the minority, okay, the presiding officer, now designated as the speaker, you are in the minority, but the law empowers you or gives you the authority to compel absent members to come, not majority. You say where you lack a quorum, you can compel absent members to come to form a quorum, not majority. Now you're telling us that this quote-unquote majority, okay, try to call the speaker, which is ultra-virus, to come to meeting on the other side. And we have said it clearly in the interpretation of Article 33 that, yes, the only thing wrong here, there is a speaker, you are the speaker, but you are in the minority. To compel, you don't have the law. So does that, with your argument, does that give the right to those absent members to go and form themselves into a majority bloc?
You don't form yourself into a majority bloc. You are a majority bloc because you are 43. And now the one increased up to more than 50. And at that moment, it's going to be
because you are increased to 100. We are saying, we said, and we will say again, we say it again, you can be 1,000. But we say at the time of that petition, we were clear, we say in the instant case, the legislature not having given an enabling statute to ensure compliance with Article 33. At that time, there was a presiding officer, there was a speaker, okay, that would force the court, to do this. So the court cannot do for the legislature what they should do for themselves. This is what we said. So what made you go now and designate another speaker when there was already a designated speaker when this was spoke?
There was not a designated speaker as such in all cases. Let's go back to your own statement of facts.
Yeah.
Let's assume they have all had it. And when the speaker was never able to get a quorum, why 43
when we need their rules, their regulations, and we don't just put them together because we feel like working with all these rules and regulations for this very reason. So that when there's a crisis or something, we can refer to. Let's take the Supreme Court, for example. We meet here in this people. Then all of a sudden we have a problem, and we go back one time on the 6th floor when we had a COVID floor. Madam CJ, you can come up here to us. Other than that, we are going to proceed without you. You understand what I'm saying? So we have rules here, procedures for opening a court. We're supposed to open the court. We're supposed to do that. And you see, the problem we have if we don't follow those rules and procedures is that precedence for other groups. Because if this group in the majority can say, we can't do something things, we are going somewhere else for ourselves, and we are the majority, we are going to run the House of Representatives, then we ask them, so why are we in the Supreme Court? Yes, the Supreme Court has happened before, forget the rules. Let's proceed. And let's go and open our Supreme Court on the 6th floor. And call her to come and join us. If you are sick, that's it. You'll take me, make me the Chief Justice, and we'll go. Let's go. You know what I'm saying? That's why these rules are very important for us to follow so we don't have this kind of crisis. It's true. We don't have anything to do with who the Speaker is or how they elect him, how they decide that he should, leave or all that law. We don't have anything to do with it. We have rules. We have rules, and that's what they say. And the rules, looking at the Constitution, clearly says you got the right to choose the Speaker, to elect him, and to remove him. Finish. That is what we are seeing here. But you cannot say, because we need the majority to hear the law, instead of following the rules and say, I will remove you, and continue. So you come back. And you decide you can do whatever. But you decide that you're going to take the majority elsewhere and proceed with another house. My issue for me, and my issue here is because we like to follow the Constitution, the rules, the guidelines that we have set for institutions. And that's how we get this country properly. If we don't follow it, we always have the situation that the country. So, let's say to you guys, how in the face of all the rules and procedures you have, that you still have another group operating, and take into account the Constitution, operating when the Speaker is present, when they have not, according to their own rules and procedure, properly remove the Speaker from office. If they have not done that according to the rules, how can we get this?
Your Honor, let me first leave horses. I think you have a lot of good horses. When the leader of the parliament loses the confidence of the majority, resigns. That's not wrong. When you lose the confidence of the majority, you resign. Because you are not able to conduct parliament with all support of the majority. When you lose the confidence of the majority, be the leader of parliament. Because when you are the majority, you don't conduct parliament. If you tell them today, go back. And let's speak over resign for you. And they say, no, we are the majority. You have created a dysfunction. And they say, no, we are the majority. We have a head speaker, which by the Constitution says can act in the absence of the speaker. You created a dysfunction. You created a dysfunction. I say anywhere to look at. I'm not saying that we will do. You created a dysfunction in the governance of the country. The argument is very strong when it comes to trying to maintain continuity. But the problem that we have is the law. It is the law that we have in the parliament, acting within the confines of the law. But then it is time. Suppose tomorrow the 38 members of the House meeting against the level. We don't want to sit under the speaker. There are 38 members. That's a simple majority. Then the speaker now lacks the ability to preside. Then the members meet. They say, you know what? We don't want that speaker. So we're not going to preside over, we're not going to go and sit normally. We're going to put in our own chambers, we'll have our own sections, and whatever. You know, it's going to actually a good scenario for our system. You see, in a parliamentary system, the law is built in a way that a vote of no confidence automatically takes out the prime minister. That vote of no confidence takes out the prime minister. But in our system, they said a 49 member vote is the one that will take out the speaker. So I don't see what is wrong with the majority that is about 50 now. Going there, say, okay, speak up all the sections, say, okay, we have the petition, here's our petition, we don't think that we remove you. Then we want to remove it for reason, and after that, let's have a vote. So step aside, in the chambers, and then the speaker refuse to step aside. Then the majority can case. You see the guy gets there. Step aside and you refuse to step aside, the law will begin to step aside. Then the law will begin to step aside. But when he is still sitting, he's there, you have not removed him, then you want to open a parallel section. You know, a parallel section. You see what is happening? That creates chaos. That creates chaos. There is nothing that prevents the majority from going in the way the speaker is and then raising the issues before the speaker actually in the gap. And suppose he listen. I would listen to it. Oh, there's a rule of that. There's a rule. There's a rule in the House of Representatives that the presiding officer can seize and hide on the agenda. There's a rule. There's a rule. So if you bring anything against the speaker who is presiding, he can seize it. There's no rule. Your Honor, if there is no further, if the members of the legislature elect to make the rule that gave the speaker that draconian power, I will call it a draconian power, to then be able to seize, we all sitting as a member of the House of Representatives. They will say, oh, speaker, you get the right, anytime you take time, they seize it. They can seize it. We gave you that right. So they will have the power right. The honor in the agenda is prepared by the honor in the agenda is prepared by that is. So what we do first, we will have to find a way to abide by the law. The law is to remove the speaker. There must be a section of the House of Legislature, and that section, the issue of the speaker removal must be raised, and the speaker must be accorded due process of law. Then, as we are talking about, we are getting to go along with the rules of the House of Representatives, and then we make it our duty to make ourselves go from leader to leader. But the issue that we have now is how can we bring order, stability, and get chaos out of our system of governance? That's what we are more concerned with.
Can I suggest to Your Honor that there is no chaos until you call it chaos? Let me continue, Your Honor. There is no chaos until you call it chaos. There is no chaos until the press keeps saying chaos, chaos, chaos. Because there is no chaos. Let me continue, Your Honor.
Councilor Chairman, I wonder what you would term as chaos if you got up one morning and saw your house on fire. You take judicial notice of the fact that all of Liberia woke up in the early hours one morning and the portion of the Capitol building was on fire. That's chaos. Councillor, when we take judicial notice of the court, this court of last resort, take judicial notice that in the morning too, the news everywhere, including foreign news, carrying that people are fighting over a space for the speaker, a car space for speaker, and videotaping it after that as chaotic. When people are openly emboldened to videotape, citing acts and utterances against the court of this republic, this sacred place, okay, without even having knowledge of the law, I call it chaos. I don't know what you would call it. So don't let the little thing.
Your Honor, please. I think
I always say that as chief justice.
You are taking me 5 feet. Yeah. I was saying chaos within the House of Representatives. That was what I was referring to. Because if the House of Representatives were referring to not fire or anything else, because you tell me that before. But what is important, and I left for us to be practical. If the majority never sits with or over, would that House operate? No.
Chairman, that's my problem with your line of argument. Trying to give relevance and legality, that's the legality to this choice of majority. The law we say, this is the law. Whether a small number or whether a minority, they were joined from day to day and under the presiding officer designated as the speaker until we can find a law on how to bring the members to constitute a quorum. So with this new nomenclature of this majority, I haven't seen it legally in the books, within our jurisprudence when it comes to the legislature. Quorum, and the law says this is how a quorum will be act. This is how a quorum will be act. Okay, Mr. Presiding Officer, Mr. Speaker, members of the House of the legislature, you, the legislature, this court says we have to have law to say how to compel members to go and sit for the business of whichever house. You have not done that law. There is no law. Then you come with this line of argument of majority, and that's what gets me, right up. Where is it? What is the legality of this majority?
The only majority can do it. What is the majority?
A quorum, Councillor. A quorum. There is a difference, Councillor Sherman, between majority and a quorum. There is a distinct difference.
A quorum is what?
I'm pretty telling you, I said there is a difference.
Remember the law. You have the majority. You have 73. So that is
Including the presiding officer.
So that is to make them a quorum.
Presiding officer, designated by the Constitution, who is the Speaker of the House of Representatives.
That's what I'm saying.
Who is the Vice President of the Committee of the Senate. If the Vice President is not present, then the President will declare this oath. If the Speaker is not present, then the Speaker takes I'm not saying we agree with the majority is the but I think we have to divide because I'm the speaker.
If not, and then this is
No, this is not. If the speaker is absent, is outside of the
Your Honor,
he's sick.
Your Honor, I gave deference to you because you are a justice. From my experience as a senator, the Vice President is sitting in his office and the President will tell you to tax.
Because he allows it. There is a coordination on that. The Vice President never got a
You said, if it was the intention of the drafter of the Constitution, if it were the intention of the drafter of the Constitution, that once the Speaker is not there, the House cannot.
Mr. Chairman, there is no Ministry of Justice participation.
Nobody
in this proceeding.
Your Honor, you gave an opinion.
Justice Stephen,
he gave an opinion. Your Honor, are you telling me that in executing the Constitution of the executive, the Minister of Justice did not advise the President how to proceed? So I'm just
let it be because sometimes you are shy away and you have to deliberately hide from the public the law. The Minister of Justice under our law, one of his primary duties is to give a legal opinion to his principal, the President, and this is he's upon in a whole coded file and work for opinions of the Attorney General. Opinions of the Attorney General. So look at us here, we don't know as though the Minister of Justice, the Attorney General gives an advice to the President as though the Attorney General is fighting this court or disrespecting this court. No way. Let the world know, let the public know that any opinion, whether on a Supreme Court opinion or on any aspect of the running of the country or the government, it is the duty under the law, the executive law, for the Minister of Justice to give the President an opinion, and it's qualified, it's there for everybody to see. Opinions of the Attorney General. We go to the Ministry of Justice now, we got a qualification of so many opinions of the Attorney General to the President of the Republic of J.J. Rahman. So you look at me yesterday and you sit quietly and the public castigating the court as well, and you are supposed to be educated there. You want to close? You want to be responsible? You want to close? From henceforth, adequate protection for every member of the Supreme Court. You will be closing
But you all please do what we're responsible for how you come across. Let us say anything about what is coming across. I'm having a case with you. I'm not educating the public. Because I don't talk to public. I talk to the court.
That's good. But I'm there educating the public. When we go to the video, people made all kinds of comments, but we felt that somebody said, oh, I understand the opinion, but the layman, the way of it, would not understand. So we said, we're not writing out there, we're not writing for laymen, we're writing for people who understand the opinion. And we simply say, gentlemen, the Constitution says it might not be clear. Let us interpret do this, do that, and go and get together and solve your problems. We don't want to come up here and say we're solving problems for you, because the Constitution and your people see us education. So go now and act as per the rules and as per the Constitution. We left it at that. They want us to say you're wrong, you're right, the case is that. But we didn't get that from the opinion. So the clients, we interpreted it and went. That we felt was sufficient for them to go and do what was right as per the law. But we get a bit of information that says, hey, we got a justice minister who interpreted it. And so the majority, they proceeded I guess as per the petition, whatever. Well, a lot of information before us. And let's hear the Minister of Health interpret how we do this right.
No, I just want to say, so to say that, let's say about, just the fact that you mentioned the Minister of Information, as if it is a
He advises the President Executive, the Minister of Justice.
Yes.
He advises the President on how to execute in your ruling. You do what? You see, I know about the document that he wrote. You see, for me, I don't know about hearing from the grapevine. Please, y'all.
Councilor, we want to close now and pray.
Your Honor, this is a democracy. This is a democracy. And in a democracy, it's the majority. Somebody might not want to hear the word majority, but it is the majority. Even among you five here, it is the majority. It is who? The majority. You said you did not recognize the resolution, but it was given to you. Some are 15 members of the House of Representatives. Now, one member is the majority. Is the majority that is the president. But there is a procedure for that election. Right? It's the majority. But the majority of the people are the satisfied with the government. They can just come and say, oh, we have election today, then moving. There is a procedure. The law made a procedure for the majority to act. And the reason for that is to avoid what we have just said here. To avoid that, because if you just say the majority, sometimes we have a very ruling majority. But so in order for it to be done properly, the law provides a procedure for the majority to act. If you see the complaint of the 6 members of the House, you say you don't want to look at it. Did you see the minutes of the investigation? You say you don't want to look at it. Did you see the procedure they follow? And the procedure they follow, all of those instruments will have been looked at. And the procedure they follow, it is just a procedure that we are more concerned with. Follow the procedure. The majority acting with the power, exercise the power to pay and in the form that the law provides. The law says, go down there for the 9 person, move the speaker. That's what the law says. If you believe the speaker should be there, but the 9 of you go to section and then you raise the issue, speaker, we have problem with you, we don't want you. So we want to have the hearing based on that. And then the law provides that you must be in the due process. After the due process, then you vote. When you vote, then when you get the 49 vote, the speaker will automatically be on due process of the court. Look at our documents and then you can decide about the due process. Can I see the majority? We agree what must be done based upon the law. The law provides all the because when we started, there was a deputy speaker. That's what the law says the speaker. When the law also says the absence of the speaker, the deputy speaker, the speaker was not absent. That was saying that. I don't understand why the speaker not being absent when the majority is sitting and the speaker is not there and you say he's present. The majority is sitting, the speaker is not there, they say he's present. He's not present. No. The same question I raised with I was nothing today. It's the same question. I never went to the detail of this matter. No, when I asked the last time, I said, I've been done. My question is, was it a mandate sent to the court below that was violated by any party in the proceeding? That were you coming back, or party coming back to the school? Go on. None whatsoever. None whatsoever. The mandate for things that they say was through the House of Representatives. Go, any city you have must be what? Minimum a simple majority. You have to finish. Because you follow the two parts of the Constitution. You said first, conduct yourself in people will act. Which means, any city you have, there must be a quorum. Simple majority. That's number one. Then Article 49. The House shall elect a speaker, who shall be the presiding officer, his deputy speaker, and other officers. Then it goes on to say, if you want to remove your officer, your speaker, and deputy speaker, you need 2/3 to remove them. Those are the two articles of the Constitution which say when you comply. And we are saying there was no sitting when there wasn't a simple majority. We presented governors of the House to you. There was no sitting, there was no simple majority. They have not identified a single sitting that was a simple majority. And we also told you that there was compliance with Article 49 of the Constitution because 50 or members of the House of Representatives signed a resolution to remove this speaker. Now, one signatory has come and said we didn't sign. Now, one signatory ever filed a petition for reconsideration of that decision. We put all of that in already. So, what wrong has been done to come back to you?
They signed it, just come in and get the paper and sign it.
It didn't happen that way. We show you the minutes. We attach the minutes. We attach the complete. We attach the document.
There's a procedure you have for removing, and it's open to the public.
Your Honor, it wasn't in time. In fact,
Councillor Sherman, comment 3.
Your Honor, our prayer is simple. There is no business like that.
Don't you have your prayer in your brief? Kindly yield to the prayer in your brief, Councillor. Thank you.
You want me to read my prayer to you?
No, just sit it there and declare. We put it on the minutes that the councillor yields to the prayer until he is free.
Wherefore, and if you are before voting, respondents pray your honor to declare one, that respondents have not violated the order of amending of the honors, opinion, and judgment of 6 December 2024 in the Constitution. 8. 2. That the amended bill of information is meritless, unfounded, and frivolous, that the prayer of said amended bill of information is denied, and 4. That the entire bill of information is dismissed with cause against the opponents and appropriate sanctions imposed.
Thank you, Councillor. Informant, please come and pray. Justice Wright proceed.
Thank you.
And you will pray.
I will receive that.
Yeah.
Your Honors, I will commence where my big brother left off.
Mr. Marshall, if there is not perfect quorum in this place here, please remove the persons who want to fight here. If they do not want to move, let me know so we can call in the police. Thank you. Proceed, Justice.
Thank you. The question was, or is, what violation of the mandate of this court has brought us back to us? Brought us back to you? Let me answer.
No, don't answer it like that. The question I want you to answer the question, what is the mandate?
Good.
What is the mandate?
You ordered that the House should abide That's what you ordered them to do. How do they abide by it? Who ordered who? The Supreme Court.
We decide that place when we say we order you, the legislature. We that place in our opinion where we order
you made a declaration.
Oh, now you qualify it.
You made a declaration. Yeah, but wait now. That declaration had to go back. The going back is a mandate. Yes.
Okay.
You made a declaration.
Okay.
You said any action. Yes, sir.
In a declaratory action,
yes, sir.
The police has to declare rights. Right, yes or no?
Yes, sir.
When you declare rights,
yes,
the parties are expected to govern and say accordingly.
Thank you.
But the court does not give order to say go this way and go and lay by it.
You know,
how do you do that?
I agree with you.
You get money and say go and do X, Y, Z. Good. You declare the right. This is the right. Good. The right.
It is to go and do the X, Y, Z that has brought back because they have not done it.
But the way you
I have not done it.
The way I did that with X, Y, Z.
You said any action done or taken in violation of article 33 is not a violence. It's illegal.
In my mind,
it's illegal.
You the so-called majority don't proceed to have any sex. Don't proceed to have any sex without forum.
That's the question the Chief Justice asked earlier. What was to be done or to be observed by Speaker Kofa? What was to be observed by the majority? What was to be observed? This bench said, as long as Speaker Kofa sits with a minority lack of a quorum, nothing he can do, he must compel. And let's just say there's no way we can compel because there's no law to that effect. That's what Speaker Kofa. After the super majority, the court says that all actions.
The action of the super majority.
Yes, sir.
The court doesn't say what.
Now, I'm coming now. That whatever actions they took, which violate Article 13, are also virus. We have come to tell you, Your Honor, that everything that has happened since December 6th is also auto virus. They have disobeyed.
So, this court did not answer the question of president, did not provide solution to the question of president, right?
Say that again.
This court did not provide solution to the issue of president.
Your Honor, in my opinion, this court spoke in English. This court spoke in English. Who can understand English?
That English, in my interpretation, is minority, you cannot proceed.
Thank you.
Majority, you cannot proceed without the speaker, right?
No, A and B. Majority, you cannot proceed without a quorum, and you also cannot proceed if the speaker does not preside. That's the violation of the majority.
I'm saying that.
Yes.
So that left the executive and the open, right?
Yes.
No, that majority, right?
Your job.
So my question to you now is, how do we as a government put our function?
Your Honor, the function of this court is to make declarations. And that what is right and what is wrong.
And the reason that we could see that we had this
when you do that, Your Honor, once this court has made a declaration, if I say to you, I'm going to put it in jail to grab me out of there and throw this person and put it up right now, that's a control. Enforcement of your decisions is not executive branch of government. In this case, this court said, let the House of Representatives abide by Article 43 and 49. Conduct yourself according to what the law is. That's what the court said. And we have come to say to you, they have not conducted themselves according to Article 39 and 33. They have not. For example, since December 6th, the acts that are authorized, number one, they claim to have passed the budget. That's one violation. Two, they remove. Yes, Your Honor.
I think this is a good time for you to pray.
Yeah.
informants respectfully pray your honors. Relax.
So maybe you're brief, please.
This yield to the prayer in your brief. Okay. Otherwise, has been constant on this.
Correct. The informants yield and submit to the prayer contained in their brief and respectfully submit.
Really reserved matters suspended. Mr. Clerk, call case number 5.
So folks, thank you so much. We just listened to lawyers representing both the majority bloc and the minority bloc here in the Supreme Court of Liberia. And both sides argue the bill of information filed by former House Speaker Councillor Folante Kofa and Chief Justice Salenyu, along with the 4 associate justices, have reserved rulings into the bill of information to be announced in subsequent time. So folks, thank you so much for following LNTV and Aram Talo. But this live happening, Fabian here, I've also been here. We both have been here bringing you this live happening. Thank you so much.
I want to speak to the nature of the matter in terms of what the Supreme Court was, the arguments and everything that was done there, because I'm prohibited from doing that as a lawyer myself. I cannot speak to the merits, the argument and everything else that went in there. We leave that with the Supreme Court. Hopefully, in the shortest possible time, the Supreme Court will come down with his opinion. So we should all bear patience and wait for the Supreme Court to come down with his opinion.
What's your expectation?
Well, I wouldn't want to pass judgment again, because probably doing so might infringe upon my role as a lawyer myself as well. So I wouldn't want to pass that judgment, because the thing is important that we all have an understanding as to how the court system works. Now, when a matter is at the level of the in court, the matter is in court. That means it is sub judice. The court has taken seize of that matter, and so the members of the public, including lawyers, are prohibited from speaking to that matter until the Supreme Court renders a decision. So I want to abide firmly by that. I want to wait. I don't want to make any judgment. I don't want to pass any opinion about what's going to happen until we all hear from the Supreme Court. Thank you. Let me just add that I trust the Supreme Court. I believe in the integrity of the Supreme Court, and I must assure you that the Supreme Court will ensure that justice is done in this matter.
As chair, you chaired the Senate Committee on Judiciary. At a point, you frowned at the Liberian Senate for finally deciding to work with the House of Representatives, especially under the leadership of. Do you still stand by that decision, sir?
Absolutely, and firmly.
So it means that you took a side in this time.
Well, it's not about taking a side. It's about expressing my opinion as to what I thought was the best way to proceed and resolve the matter. That's it. It was not about taking a side. So my position was that about who was in the right and who was in the wrong. It was what the law. I was speaking about what the law said. What is the law in this matter? And I fully quoted the law. So in a matter like this is how the law says it should be handled. And that's the opinion I provided.
Thank you very much.
Still here. I'm seeing Nathaniel Magu of IGB County. So folks, we are here this afternoon the grounds of the Temple of Justice in Monrovia, where the full bench of the Supreme Court of Liberia just entertained legal argument between both the majority and the minority bloc of the House of Representatives, and Chief Justice Sanayo had reserved ruling into the case, and the final ruling will come out in subsequent time. And in court you have both Councillor Van Sherman, the lead lawyer of the majority bloc. You have Councillor Wilkins Wright for the minority. You have Councillor Arthur Johnson for the minority. You also have Councillor Gineto Masakwe, who was one time nominated to head office of the